So recently a question was asked on the purchase of a property from a developer and whether a purchaser would be responsible for paying VAT or transfer duty on that specific transaction. So the first thing that must be noted is typically developers are VAT registered. And even though residential accommodation is exempt, so the rentals received in a residential accommodation are exempt from VAT being paid on them, the actual sale of a developed property is considered to be VATable because it's actually a supply that's being made by the developer to an end user. So yes, if you buy from a developer, most of the time VAT would be payable. But, and this is where the question came in, most developers include VAT in the purchase price and actually in fact include transfer fees in the purchase price in order to make it more appealable or attractive to a purchaser. So this particular question about whether VAT or transfer duty is payable when buying from a developer isn't really the contrast or the confusion that we experience in practice, because typically the answer there would be absolutely a VAT would be payable. Most developers you'd expect would be VAT registered. If the person selling the property is a VAT vendor and the actual supply, in this instance, the property, the goods, are VATable, which they are because it's the sale of an actual property, then yes, VAT would be payable. Now, the next question, though, is how do you determine this? So when buying a property, is there a risk or a fear that all of a sudden VAT may be payable? How does a purchaser know, especially in instances where the VAT is being passed on to the purchaser? A lot of contracts have a templated clause in them that it's basically a blanket clause that passes the VAT obligation onto a purchaser simply by saying that if it transpires that the purchase price should, or rather that the seller should have charged VAT on the purchase price, that any VAT payable will be levied above and beyond the purchase price. So that 15% gets added on. Now, if it doesn't say this, the general rule in the VAT Act is that if a price doesn't stipulate whether it includes VAT or not, it's deemed to include VAT. But if the OTP actually includes a provision stating that VAT would now be payable above and beyond the purchase price, then the purchaser is going to be stuck to pay VAT. Now, this has financial implications on all property transactions because firstly, there's a threshold for transfer duty. So a purchaser under the 1.1 million rand mark would not expect to pay any transfer duty at all, whereas VAT is payable on any amount. So now there's an extra expense that you weren't aware of. Secondly, and usually the case up to a certain amount, VAT is more than the transfer duty payable. So it's also a big surprise in any transaction for a purchaser to now all of a sudden have to pay VAT. So if you want to double check, or if that clause is in the agreement and there's no warranty in the agreement that stipulates very expressly whether it's VATable or not, I personally would include a warranty. So I'd insist that a warranty be included that stipulates that no VAT is going to be payable. It's a transfer duty transaction. Alternatively, I would insist that something be included that stipulates that the purchase price is inclusive of VAT if VAT is payable. And last scenario, if none of that works, I'd probably walk away from the deal, to be honest. But if you really want to double check, checking with SARS on their website whether the seller is a VAT vendor, even if it's just to put your mind at ease, on the website it would stipulate whether they're registered for VAT or not. So yeah, just a few little things about VAT and developments.
Okay, yeah, absolutely.